That means you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Has probable cause has already been found on this, right?
Yes, Your Honor. So she, it's already been found, but this case is really old. She didn't come to court. So it was just kind of, she got rearrested for the same charge.
Okay. Where's this from? If you don't mind.
Your Honor, I'm sorry, I did
Just
get
Neves.
Eames?
N.
Yeah, thank you.
N-I-E.
Your Honor, the offense date was October 11th, 2023.
Where from though?
Walmart.
Oh, where? I apologize.
Walmart.
It was Walmart, Your Honor.
Hey, can you look to see if discovery is complete?
Yes, Your Honor. It does look to be complete, although we'd have to talk about the videos. Yes.
Well, just to get this case, because they already had a prior PTI offer, which you're supposed to do an anti-theft course. They just reinstated the offers. They said that they'll still take the offer.
Have they said that they're going to keep the offer?
I spoke to them this morning.
Okay.
So she's going to complete this class this week, and I'm going to send it to them for dismissal.
This is the Miranda-style warning you've heard about on TV. The judge is reminding the defendant that anything she says can be used against her, and that she already has a prior offer for a theft prevention class. What's unusual here? This case is over 1,200 days old. That's more than 3 years stuck in the system.
Okay, this case is 1,269 days old. I'm now putting a monitor on your ankle so I know where you are at all times. You have 2 weeks to get this class done. If you don't, I'm going to set your case for trial. Do you understand? You get no more resets after that.
Okay.
Okay, all right.
Thank you, Your Honor.
So Felicia, if she can get today, please. You are Mr. Vasquez Lechado.
Yes.
Sir, you're charged with driving while intoxicated, facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 21 days in jail with credit for the 7 days that you have done.
Yes.
You're pleading guilty to this offense and it is now going on your record. You need to understand that from now on.
We'll listen to that. The judge isn't mincing words. Even if you have a sip, don't drive. This is where courtroom drama meets real-world consequences. Do you think this kind of blunt warning actually changes behavior? Drop your thoughts in the comments because many repeat offenders say they only had a little.
Facing a minimum of 30 days in jail for any new cases that you pick up. If you ever get pulled over from now on, officers will look at your record, they'll see a prior DWI. If they smell alcohol or dope on you, it's probably not going to go well. So from now on, I would never, even if you have a sip of alcohol, don't get into a car and drive. It's probably not going to go well for you. You're giving up a lot of rights by entering into this agreement. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it goes on your record. It'll be there forever. Is this what you want to do?
Yes.
You plead to the offense guilty or not guilty?
Guilty?
I'm going to find you guilty. I will follow the agreement, send you to it. I'm now going to suspend your ability to get a driver's license for 90 days. Do not drive until you get a license. And good luck to you, sir. Thank you, Mr. Moore.
And Your Honor, if I may mention, I did want to mention something else, Your Honor. This was a case that I was appointed to maybe like 2 days ago. I did speak to Mr. Vasquez, let him know that not all the evidence is in, and that he does have the right to that. He has been in custody since January, he got transferred to ICE, which he says he no longer.
So
wants to wait for the other.
you need to understand that not all the evidence is in this case. By getting all the evidence, it's very possible that she may have a chance to fight your case and beat it. Once you plead guilty, there's no turning around. You cannot come back and return this like you don't like it from Target. Do you understand? Do you want more time to fight the case or do you want to continue with this plea?
I'm fine like this.
Okay.
¿Está
All
bien?
right, I'll make a documentation that
Thank you, Your Honor. I appreciate that.
Documentación de ahí.
that it's It's against your,
Yes, Your Honor.
all right, come on up.
How you doing? Hey, Judge, good morning. This is Mr. Jalen Calhoun, Judge.
I'll sign this real quick.
Don't say anything about the case, okay?
All right.
Use the focus of getting to the proper place to handle your business.
That's right. That's right. I'm so confused.
Scott Sanders?
Okay, what is his name?
His name is Jalen Calhoun.
Good morning, Mr. Calhoun.
Good morning, what you doing?
So it seems that you are one of 4 co-defendants that we have on a case arising out of another state.
Yes, sir.
You are wanted out of,
Louisiana, Natchitoches Parish. I butchered the pronunciation, but
Natchitoches.
Yes,
What is it?
Natchitoches.
That.
Louisiana.
Lawyer is asking me to set you a bond, but I don't know. I don't know you. I've never met you before, and I have a very short amount of time to get to know you to see
Right.
what kind of person you are.
right,
Paper really tells me who you are. The words coming out of your mouth, I just,
right.
right. So tell us about Mr. Calhoun.
Your Honor, he's wanted out of Louisiana for transfer and possession of stolen vehicles, not equivalent to theft of a motor vehicle, and him and 3 other individuals, one whom is charged with UUMV, were found same day where they stole a vehicle, and we have a parallel charge with Louisiana where they're charging him for the theft, and we have for the
But the
driver.
thing about it is, I wasn't there.
Do you really think that you can just start spitting out something? Where do you think you are? Really?
My bad,
You think that this is helping you, Mr. Calhoun?
sir.
You're not at home. You're not on the street. Okay. Please.
Your Honor, the same day that they stole the vehicle, which was captured on surveillance off campus, they transversed state lines and came to Texas, and they were found in Harris County with obviously traffic infraction being the probable cause, and found with all 4 occupants of the vehicle. The fact that they transversed state lines, they would be opposed to a bond. There was also, and because I took a charge, I know before the office reports out, is that there was also a firearm found on one of the passengers and that they were trying to conceal. At the time, the officers were getting everybody removed from the vehicle, and obviously 2 of them being under the age of 21. So they would be opposed to a bond for.
So hold on a second.
Yes, Judge.
It's a stolen car.
Yes, Judge.
Out of Louisiana.
Yes, Judge.
They come to Houston,
Yes,
all 4 of them.
yes.
How do we know the other ones knew that it was stolen? Do we have any kind of,
Complaint in Louisiana, and they did it in real time. And the complainant stated none of the occupants in the vehicle had permission to take the vehicle.
I know that.
Oh,
But how do we know that they knew that it was stolen, right? So what if I come pick you up in my car?
Oh,
It's
I
a
see
stolen
what you're
car.
saying.
You have
So-
no idea it's stolen.
I see.
Like if everything's ripped off in the inside, you got like, there's a screwdriver for the steering wheel, and the steering column's been ripped off. Then there's facts that lead you to believe that it's a stolen car.
So for running the plate because it was reported stolen, and the fact that it was, well, at the time of the, I'm sorry?
That's still,
No, again, on surveillance video in Louisiana, that they have it in Louisiana, that these are the original individuals that stole the vehicle. That's how they knew, that's how the officers in Paris and the officers in Louisiana knew that they knew it was stolen because they were the ones who stole it.
they have them, you saying on video?
Yes, that's what
All
I'm
4
trying to,
together is taken?
yes, that's what I'm
Okay,
trying
well,
to.
that's something.
Can we see this video? I haven't seen this video. It's
You're not gonna get to see the video. That's what the
That's in
underlying criminal
Louisiana.
case.
Well, you're basing your decision on a video that the prosecution that says he saw, you haven't seen, I haven't seen.
I just want to know how they impute the thievery to him.
Correct.
And he's saying that there's a video.
Because of a surveillance video.
And the Louisiana officers were telling the Harris County deputies that they have it on surveillance video. That's how.
Specifically what? Where was my client? Was he the one?
We're not gonna get all that.
Right, but we're talking about that.
Our criminal history?
No, Your Honor. This is based on flight risk. They literally transverse lines the same day they stole a car.
It hasn't been proven that he knew it was stolen.
How many got charged with the UUMV?
The driver, because that was the only
That's the only one.
driver, right?
So your position on bond is what?
There's no bond because of the flight risk. They literally fled the state the same day within 24 hours, really 24 hours within stealing a car. Judge. They literally fled the state.
They keep
stealing a
saying
car.
they stole the car. He didn't get charged with stealing the car. He's not in the vehicle. He is charged with transfer.
No.
He
He is charged,
he is
but in
charged.
Louisiana.
Well, then that's a,
He is charged, but in Louisiana.
okay, well, he's
Here,
being charged with
just didn't
that.
charge
Just-
Here's where things get tricky. Multiple defendants, stolen cars, state lines crossed, and even a firearm involved. The judge is wrestling with the balance between innocent until proven guilty and the risk of letting someone accused of fleeing go free. This is where you see how bond decisions can make or break a case.
because he's charged with it doesn't mean you're going to convict him. I see like very good arguments as to why he shouldn't be convicted. Secondly, if we're talking about flight risk, he was a passenger. He hasn't had the opportunity. Where was he going? Did he know he was fleeing the jurisdiction? He doesn't know that it's stolen. Like you said, is the steering column broken? Okay, at that point, perfect. He should have known. There's nothing to say that that's what happened in this case. We're assuming the worst. Let's assume the best. He's presumed innocent. Let's not assume that he knew he was committing a crime. Let's presume he was innocent. So in that case, let's give him a bond. Let's allow him to go and fight this case. He can't fight it here. He's fighting an allegation that we don't have, the surveillance video that we haven't seen. Let him go fight the case over there.
21, sir.
I still stand on no bond.
I mean, I'm
Regarding the flight risk, and so.
Well, you got to understand, in life, there are consequences to action, right? When you hang out with dogs, you get fleas. I can set you a bond, but you need to understand from the time that you're released, we give you 2 weeks from the date of that release to go turn yourself in to that parish in Louisiana. If you fail to do that, I will revoke the bond that I'm going to set here. I'll set it at 0. I will not give you another one. You can't run forever. At some point, we'll get you, and then that time, when we do get you, I will physically hold you until Louisiana comes and gets you. Do you understand?
So if I go down there, I'm at the bond down there 2 months.
That's correct.
Right. The thing is that I will probably set a bond around $5,000. You'll probably have to make all of it because you are a flight risk. You're wanted out of another state. If you waived yesterday, we have buses coming in and out of Louisiana about 2 times a week. So if you keep the waiver, you'll probably be back Wednesday. At the latest, Monday, you'll be back in Louisiana Monday-ish. Where if you want to bond out, you can, but you're going to have to make it on your own to Louisiana. And then you'll have to bond out. Or no, you're going to have to turn yourself in over there. You can't bond out. Is there no bond set?
I believe it's no bond. I'll double check.
You'll have to turn yourself in there. So if you want me to set a bond, you have to withdraw your waiver and you're going to lose the credit that you've built up toward them. Because if Louisiana doesn't come get you here within 14 days, we release you regardless. And then you don't pay anything. You're going to get released. So I'll let you talk with Ricardo and make the decision what you want to do.
Yes, sir.
What amount would you be thinking, Judge?
5,000.
5,000? Judge, he is 21 years old.
Yes, sir.
He would be seeking the support of his parents. It would be a bond that he's got to post 100% on. Would you consider going to 2,500? No? Okay, fair enough. I'll talk to my
You'd
client.
even get a bond, Mr. Calhoun, really. And I don't even know if I'm going to do the other ones as well, I mean, I don't know.
I'll
So
talk to my client, Judge. Thank
Okay.
you. Appreciate it.
I'll just read you the PC summary again. So on March 23rd, 2025, in Harris County, Texas, officer was dispatched to a servant's call and met with the complainant witness, stated that the defendant is her husband. The complainant witness stated that she told the defendant that she was going to move back to Arizona that day, and they got into an argument. The defendant then told the complainant witness to hit him in the face. The complainant witness then struck him in the face 3 times.
right.
The complainant witness then stated 10 minutes later, she went into the bedroom where the defendant then laid down on top of her, grabbing her wrists, causing pain.
That's 10 minutes
That's
later.
10 minutes later. Grabbing her wrist, causing pain. Complainant witness then got one arm loose, grabbed the defendant's genitals, causing him to let go. And then the defendant then struck the complainant witness in the mouth, causing pain. And the officer observed the complainant witness to have bruises on her arms and injuries to her top and bottom lip.
How is it?
I think we are omitting some things that's pertinent to the decision that you're gonna make.
What?
That she asked, her daughter told her that you have to make a choice between,
Oh, that's right. Yeah. I
and your,
remember. And then she makes a choice of him.
and she said, I'm leaving you and I'm going to be with my daughter and grandchild. And then he comes and tell her, if you're really that mad at me, then hit me. And that's when she went to him and hit him twice. Boom, boom.
How is it fair that I find probable cause on him and not on her? Why didn't they charge her?
So I would say one is the fact that he quite literally says to hit her, or to hit him.
Can't consent
Well, but that's, I
consent
mean-
to an offense, Judge. If he
can't
tells me
consent
to
to
shoot
assault.
me,
Yeah, no. I mean, you can, like,
Yeah.
boxers consent
You
to
can
assault,
consent to
right?
assault. That's.
But, I mean, in this,
I think where we are for PC purposes, as far as this offense goes, is that it occurs 10 minutes later. Then we have essentially in a situation where he can essentially claim self-defense if he's the one, being the aggressor first, where he's grabbing her 10 minutes after this kind of initial, incident happened. He's grabbing her, then she grabs his genitals, and then he punches her in the face. I think that's where we're at as far as PC goes.
I don't think that's the law, Judge. I don't think you can avoid what had happened earlier just because it was 10 minutes later. I don't think you can take the fact away that she was the one that instigated and was the culprit of the initial assault.
but there's a long cooling down period. You know, if it's like maybe a minute or two after the fact.
Yeah, I mean, I would say.
And then, but nevertheless, though, how's it
still
fair that she's
assaulted.
not charged? I mean, why does she get the benefit of the doubt? Because she's wearing a skirt.
I mean, the code does say you can consent to an assault.
If you consent to, if you tell me to shoot you and I kill you, you don't think the cop's gonna get me for murder?
Well, you can't consent if there's serious bodily injury involved. You can't consent if there's no threat or actual serious.
Come up,
bodily
Mr. Sullivan.
Less than the serious.
I mean, an assault does occur in this case with him and her, but there's also another one that
Right.
occurs, you know, so.
I would argue, Judge, that at this point with